He opened the envelope. He saw the word lawsuit. His stomach dropped. And then he did the one thing that was about to cost him more money than the original debt ever did. He put it in a drawer. Weeks later, he came back into my branch holding a court judgment for just over $9,000 on a credit card he had not thought about in almost 3 years. This is the video nobody wants to watch, but the one that saves people from losing everything they have left. Today we are going to 180 days past due and beyond, into the part of the debt timeline where the phone calls stop and the courts take over. Welcome back to Sense and Simplicity. If you are new here, I spent over 20 years in banking as a branch manager and a district manager, but I need to be straight with you before we go any further. This part of the debt timeline is where my personal involvement ended. Once an account got this far past due, it left the branch. It went to corporate collections, then to attorneys, and then to the courts. I watched customers come back after being sued. I saw judgments hit their credit, but the legal process itself was handled by teams I never worked with directly. So everything in this video is backed by research, CFPB data, Pew Charitable Trusts research, FTC guidance, and federal law. All sources are listed in the description below, so you can verify every claim yourself. Here is where everything changes. In the previous video, we walked through what happens between days 91 and 180. By the 180-day mark, your account has almost certainly been charged off. That does not mean the debt is gone. Charge-off is an accounting term. The original creditor writes the balance off as a loss for tax purposes, but you still owe the money. Once that happens, one of three things comes next. The creditor keeps the debt and hires an attorney. They sell the debt to a collection agency, or most commonly, they sell your account to a debt buyer. And when I say they sell it for pennies on the dollar, I mean that literally. Debt buyers often pay just 2 to 5 cents on every dollar of the face value. So a $10,000 credit card debt might get sold to a collection company for $200 or $300. Your account may pass through 2 or 3 different companies before someone finally decides to sue. The phone calls you have been getting are about to stop. What comes next is not a phone call, it is a knock on your door from a process server. There are 2 very different kinds of companies that will sue you for an old credit card debt, and knowing which one is coming after you matters. The first is the original creditor, the bank whose name is printed on the card. They sue directly when the balance is big enough to make the legal cost worth it. The second is a debt buyer. These are companies that buy charged-off debt in massive bulk portfolios, as we just discussed. Their entire business model is not collecting the full amount. Their business model is filing lawsuits at scale. According to the Consumer Financial Protection Bureau, about 1 in every 7 consumers contacted about an overdue debt ends up getting sued. That rises sharply once the balance is over $1,000. Once it climbs into the several $1,000 range, a lawsuit becomes much more likely. And here is the part most people do not know. Debt buyers sometimes cannot even produce the original signed agreement because the paperwork got lost when the debt was sold 2 or 3 times. If you show up to court and demand to see that original agreement, the case can get dismissed on the spot, but if you do not show up, none of that matters. When a lawsuit gets filed against you, the first thing that happens is you get served. Someone physically delivers 2 documents, a summons and a complaint. The summons tells you that you are being sued and by whom. The complaint tells you exactly what they claim you owe and why. It gives you a deadline to respond in writing, usually 20 to 30 days, depending on your state. This is where most people make the single worst mistake of their financial lives. They panic. They set the paperwork aside. They tell themselves they will deal with it next week. Some even refuse delivery, thinking it stops the lawsuit. The FTC has been explicit. Refusing service does not stop the case. Ignoring papers does not stop the case. The deadline passes and the case proceeds without you. That same customer I mentioned at the start of this video, the one with the envelope in the drawer, came back into my branch months later looking like he had not slept in a week. He was not someone I would have ever predicted this happening to. Good job, steady income, years of on-time payments with us. He had a folder with him. Inside that folder was a final court judgment for just over $9,000 on a credit card account he had stopped paying almost 3 years earlier. He had been served months before. He opened the envelope, saw the word lawsuit, and put it in a drawer because he did not know what else to do. He never responded, he never filed anything, he never showed up in court, and the company that sued him was not even the original bank. It was a debt buyer that had bought his charged-off account for probably $200 or $300. They now had a court order in their hand for the full amount, plus several years of accrued interest, plus their attorney fees. He asked me if the bank could help him. There was nothing the bank could do. By the time a judgment is entered, every window of opportunity has already closed. The only path forward from that point is negotiating with the judgment holder or hiring an attorney to try to vacate the judgment, which is expensive and rarely successful. There is a number from the Pew Charitable Trusts, the most credible research organization on this topic in America, that I want you to hear clearly. In jurisdictions where the data is publicly available, more than 70% of debt collection lawsuits end in a default judgment. 70%. A default judgment is an automatic win for the company suing you, not because they proved their case, not because a judge heard evidence, but because the person being sued never responded or never showed up to court. Pew also found that fewer than 10% of consumers sued for debt have a lawyer. Nearly all of the companies suing them do. Only about 1 in 4 people sued for debt ever shows up to court at all. And in Michigan specifically, Pew data showed that 78% of debt collection judgments are followed by a garnishment order. 78%. This is the entire business model for debt buyers. They are not expecting a fight. They are counting on silence. And most of the time, silence is exactly what they get. Once a judgment is entered against you, the company that sued you walks out of that courtroom with legal tools you probably never realized existed. They can go to your employer and garnish your wages. They can freeze and drain your bank account. They can put a lien on your house, which blocks you from selling or refinancing until the debt is paid. The court can tack on court costs, interest that keeps accruing at the judgment rate, and the plaintiff's attorney fees, sometimes turning a $9,000 judgment into a $13,000 obligation before anyone has collected a single payment. That judgment appears on your credit report and stays there for 7 years. It can block you from renting an apartment, getting certain jobs, and qualifying for some kinds of insurance. In most states, the judgment itself stays legally enforceable for 10 to 20 years and can often be renewed for another full period after that. That means a court order entered in 2026 could still be actively collectible in 2046 or later. But how all of this actually works, what percentage of your paycheck they can legally take, which states protect you more, and the clock on old debt most people do not know exists, that is the next video in this series. If you missed the last video in this series, Credit Card 91 to 180 days past due, what the bank does next, and how to stop it, the link is in the description and on the card above. It walks through the exact window right before everything in today's video gets triggered. If you are anywhere near that 180-day mark, go watch it right now before you do anything else. Your action step this week. If you have any old credit card debt, especially anything you have stopped paying on, pull out every statement, letter, or document you still have today. Find the date of your last payment. Write that date down. Save it somewhere safe. That date is the single most important piece of information you have if any of this ever comes after you. Subscribe so you do not miss the next video. Do not be the person the system counts on.